Thank you so much. Welcome everyone to our January meeting. Thank you for those of us who joined us at the library. Tonight we are having a special meeting. We have a special guest. Before I introduce her, I just want to tell everybody who is joining as one of our members. After we speak with Rebecca and have some discussion time, we'll do the business part of our meeting at the end tonight. We want to be respectful of her time and ensure that she's welcome to join us for our youth leadership training program and our other details, but we'll be doing some additional business at the end. I'm so very glad for all of you who are joining us. We greatly appreciate your time tonight. And we have a special guest because we want to make sure that we are focused for our gubernatorial year here in New Jersey. Our team reached out to the League of New Jersey to ask about our efforts to support the Equal Rights Amendment and just generally how membership wants to proceed with our activities for the year. And we were lucky enough to get connected with Rebecca Goldman, who is joining us tonight, who serves as the Justice Reform and Legislative and Policy Manager with the League of Women Voters of the United States. Rebecca manages the leads research and serves as the policy and subject matter expert on social justice issues, including climate change, criminal justice, the Equal Rights Amendment, gun safety, healthcare, immigration, and reproductive justice. She's helped develop the League's national policy agenda and designs and implements advocacy strategies before Congress and the administration. She also supports affiliates with their state and local legislative initiatives. Prior to joining the League, she lived in New Jersey and has served in the nonprofit sector addressing sexual and reproductive health rights, economic inequity, and food insecurity through research, advocacy, public education, and direct services. She's co-authored a peer-reviewed journal article on the impact of a federal international policy on health systems and outcomes. We are so glad for Rebecca to join us. She has a short presentation for us, I believe. We're going to have a discussion and we'll be able to take questions online or in person. If you have a question, we're going to have you raise your hand in the virtual room, and I'll be keeping track of that. And with that, I would like to introduce Rebecca Goldman. Thank you. Rebecca.
Sorry, I've got a few screens going here. So can you see the PowerPoint presentation up?
Yep, it looks great.
Wonderful. Thank you so much for that generous introduction. I'm sorry I was on holiday break when you got a hold of it, or I would have given you a much abbreviated version. But yes, that's an overview of the work that I do with the League. So thank you all so much for having me here this evening. My pronouns are she, her, and as Catherine said, I'm the Justice Reform Legislative and Policy Manager with the League of Women Voters of the United States. I'm really happy to be here with you this evening to talk about the United States Equal Rights Amendment, or ERA. This is an incredibly timely topic, as I'm sure you know, and we found ourselves in a little bit of what I consider a sensitive window of opportunity when it comes to getting the ERA actually into the U.S. Constitution. A couple housekeeping items. Firstly, I'm not an attorney. I serve as the subject and policy matter expert on the ERA for LWVUS. So while I am familiar with relevant case law, if any litigation-specific questions arise that I can't answer, I'm more than happy to take them back to someone on my litigation team and circle back with you. Secondly, after today's event, I'll share hyperlinks that are embedded in these slides so that you have access to all of the resources and information that I reference throughout. So don't worry about URLs. I'll get that over to you by email. And thirdly, I recognize that there are going to be folks on this call who've been fighting for the ERA for years, if not decades. If that's been your work, thank you so much for paving the way, as well as for your patience if any of this is a review. I think it's really important to go over it and level set so that we all have a shared understanding of the issue, consistent and accurate language to discuss it, and of course, unified ways to continue our advocacy. So as an overview of what we'll discuss for the next 20 minutes, half hour, we will go over the ERA text and why it's significant today, the ERA's ratification history, the question of a time limit, which many of you may have heard of, the League and the ERA, and then some things you can do as soon as this evening. Okay, so the ERA would amend the U.S. Constitution to prohibit sex-based discrimination under federal and state law. That's incredibly consequential because it's permanent and national, and it's the only way that we can do that in one fell swoop. Now, the ERA itself is very brief, and it has 3 sections. The real meat of the amendment is in section 1, and you can see that on the screen. And that reads, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And then section 2 simply gives Congress enforcement power, and section 3 says that the amendment takes effect 2 years after ratification. Now, people may wonder why we still need the ERA in light of existing federal laws against different forms of sex discrimination, like the Violence Against Women Act, the Equal Pay Act, as well as the 14th Amendment's Equal Protection Clause. And that's a very legitimate inquiry. However, the 14th Amendment has not been interpreted consistently to apply to sex in the same way it does to other protected classifications like race, religion, and national origin, which means that when people experience sex-based discrimination and they take those claims to court, they have limited legal recourse. As a result, women and girls and LGBTQIA+ folks, among other individuals, because of course sex discrimination harms all of us, continue to face discrimination on the basis of sex, and this is clear in our ongoing fights against unequal pay, workplace harassment, pregnancy discrimination, domestic violence, limited access to comprehensive health care, which has come in the form of reproductive health care as well, and more. So what would the ERA actually do if and when it were put in the Constitution? It would, firstly, and this is really important, it would raise the standard of judicial scrutiny of claims of sex-based discrimination. So this means that if an individual brought a claim of sex-based discrimination before a court, it would require that court to use a more stringent framework when reviewing the claim. You would be more likely to be protected in a court of law. It would also provide a legal defense against the rollback of women's rights, and it would pave the way for additional legislative progress towards sex and gender equality. Okay, this is the part that I think a lot of folks find a little dry because a lot of people don't think the Constitution's sexy. I personally love it because I've been working on it for a few years, but do bear with me because this is a really important foundation if this issue is at all novel to you. The constitutional amendment process is actually established in the Constitution itself in Article 5. And it outlines the process, which is two-pronged and very simple. Typically, Congress will file a joint resolution with a proposed amendment, and it has to pass that with a 2/3 majority in both chambers. Then the proposed amendment goes to the state legislatures, where 3/4 of states, or currently 38 states, must ratify it. And as Article 5 says, when an amendment meets that 3/4 state threshold, it is a valid part of the Constitution. Now, from a procedural vantage point, then the National Archivist, who heads the National Archives and Records Administration, effectively serving as the country's top librarian, will certify that the amendment is valid through a formal proclamation. Now, looking at the Equal Rights Amendment in particular, this amendment was written by Alice Paul and first introduced in Congress in 1923, more than 100 years ago. In 1972, Congress finally passed the ERA with well over the necessary 2/3 vote, and it went to the states. And then in January 2020, so much more recently, Virginia became the 38th and final necessary state to ratify it. So the ERA, according to the Constitution, is fully ratified. Pop quiz here. And we can do this just with a show of hands, or you can put it in the chat. I'd like you to raise your hand or pop in the chat if you believe that New Jersey has ratified the Equal Rights Amendment. Okay, I'm seeing a lot of hands in the room. I'm seeing a yes in the chat. Anyone else want to weigh in?
Don't we have?
I'm seeing another yes.
I have a guess.
Okay, go ahead, Catherine.
I think we have our own law.
Okay,
That's not called the ERA, but it's a law that gives protection to all the workers in New Jersey.
that's correct. You do have a protective
Right.
state statute, and you do have some constitutional protection in your state constitution, which applies. It's not as expansive as the Equal Rights Amendment. In addition to your state constitutional pseudo protection and your individual state statutes, yes, New Jersey did in fact ratify the federal ERA. And does anyone want to raise their hand and take a guess at what year the state legislature did that? Remembering that Congress passed the ERA in 1972 and sent it over to the states. Any idea what year New Jersey took care of it?
75.
I'm hearing 75, I'm seeing 72, 76, and the answer is 1972. So New Jersey did that nice and expediently. Well done. Okay, let me close the chat here. Okay. I know this is a little text heavy. It's going to be a little content heavy. When you leave this, you're going to be an ERA pro, so bear with me and we can talk through anything a little bit later in the Q&A. But this is also important to understand because it's a lot of the opposition we hear. So why isn't the process complete? Why isn't the Equal Rights Amendment in the U.S. Constitution? And I will preface this by saying this is just one reason that people who oppose ERA publication will hold up. So here we get into a question of a time limit. When Congress passed the Equal Rights Amendment in 1972 in a joint resolution, so that was the legislative vehicle, it included in the amendment proposing clause a 7-year time limit for states to ratify it. And this is an important distinction. The time limit wasn't in the amendment language itself, it was in the language that came before it. In 1978, Congress extended that time limit by 3 years. And then in 1982, when the time limit came up, ratification of the ERA was still 3 states short. So 38 states did not ratify within the first 10 years. And at that point, particularly because of some really effective political opposition campaigns, a lot of people felt that the ERA was put to bed. However, over the years, some people have continued to work for its completion, including some state leagues, actually. In 2017, Nevada ratified the amendment, and in 2018, Illinois ratified it. So at this point, the ERA ratification was just 1 state short. And that year, the National Archives and Records Administration, which again, remember, would be the kind of final certification and publication, reached out to the Department of Justice's Office of Legal Counsel, or OLC. The OLC provides guidance in response to requests from various executive branch agencies and the president. And NARA asked the OLC for guidance on what the archivist should do in the event that a 38th state ratified the ERA, saying there was this time limit. What do we do about it? Now, in January 2020, the OLC did issue an opinion. It said Congress had the constitutional authority to put that ratification timeline in when it did in the 70s, but that Congress couldn't revive a proposed amendment after its ratification timeline had expired. So the office basically said that because 3/4 of states didn't ratify the ERA before the timeline, the ERA was no longer pending before the states and couldn't be certified. And 2 days later, NARA released a statement saying, yep, we defer to that opinion. So the archivist at the time would not certify Virginia's ratification later that year unless it was otherwise directed by a court order. In January 2022, under a new presidential administration, 5 Congress members sent a letter to the OLC urging them to withdraw that 2020 opinion and providing some legal opposition to it. And the OLC issued a statement and said, you know what, we're going to maintain our previous opinion, but the opinion doesn't preclude the judicial branch from considering the constitutional status of the ERA or Congress from acting on ERA ratification. And shortly after, President Biden issued a statement calling on Congress to pass a resolution recognizing ERA ratification. So this is a lot of historical context. But what's really important here is this. There are numerous government entities that have been engaged on this issue, including NARA, the OLC, the White House, and Congress. And earnestly, those things have been really extraneous to the constitutional amendment process itself, as outlined by Article 5. Because remember, Article 5 endows two actors with two powers. Congress can pass an amendment with a 2/3 vote, and the states can ratify the amendment. And once 3/4 of the states have done it, it's a valid part of the Constitution. So we have a fully ratified amendment, and then a lot of political finger pointing as to who would have to do what to get this officially added to the Constitution. Now let's take a look at the League and the ERA. So the League has advocated for ERA ratification since it was passed in the 70s. And our work on the ERA is rooted in our equality of opportunity position. And as you can see on the screen, that is that LWV U.S. supports equal rights for all under state and federal law, regardless of sex, gender, and other classifications. It supports ratification and publication of the ERA, and it supports efforts to bring laws into compliance with the goals of the ERA. So we've been able to address issues of sex and gender-based discrimination outside of the Equal Rights Amendment as well. And at LWV U.S., we've done a lot of our ERA advocacy work in coordination with the National ERA Coalition, which is a coalition of hundreds of organizations, all working toward the common goal of finalizing the ERA. So the background we've covered helps contextualize why the League has taken a pretty multi-pronged approach to its ERA advocacy, communicating with different branches of government. Looking at just some of the high-level actions we've taken in the past and starting with the executive branch, in 2021, the League joined a letter to the Attorney General, who's the head of the Department of Justice, urging him to direct the Office of Legal Counsel to withdraw its 2020 memo. Then in 2022, the League wrote to the White House asking the president to instruct the archivist to publish the Equal Rights Amendment. And unfortunately, at the time, those efforts were to no immediate avail. So turning to some more recent advocacy and starting in U.S. Congress. When there was a question about the validity of the last amendment to be published in the Constitution, which is the 27th Amendment, and that question came up because it met all ratification requirements more than 200 years after it was first introduced in Congress. Congress proposed and passed a resolution that declared it valid. So there's a precedent of Congress taking action to clarify that an amendment is complete and a valid part of the Constitution. If Congress passed a similar resolution on the Equal Rights Amendment, it would probably do two important things. One, it would likely spur the president to instruct the National Archivist to publish the ERA, because he's already kind of punted to Congress. So if Congress takes action, president takes action, archivist publishes. It would also provide legal support if and when the ERA was published in the Constitution and then challenged in court. So for the past two Congresses, there was a joint resolution that affirmed that the ERA is a valid part of the Constitution and that addressed the question of a ratification time limit. In 117th Congress, the House passed it twice, but the Senate never brought it to the floor for a vote. In 118th Congress, the Senate Judiciary Committee held a hearing on the resolution, and Senator Schumer filed what you probably are familiar with as a motion for cloture, which is to end debate. And that would allow the resolution to go to the floor for a vote. The Senate voted on that motion with a bipartisan majority, so they wanted it to go to the floor for a vote, but it was blocked by a filibuster, which is, of course, a 60-vote threshold. And then the House never took it to a vote. So we're seeing a lot of inaction and a lot of challenges in getting this through both chambers of Congress at the same time. So how was the League involved in the last Congress? And that was 118th Congress. Upon the introduction of this resolution, LWVUS put an action alert on our website so people could easily put in their name and address and contact their Congress members to support the legislation. And over that 2-year period, it garnered more than 87,000 letters to Congress. That demonstrates a couple things. Firstly, there's obviously huge interest and hunger among our membership to get this done. And secondly, we've got a really powerful grassroots network that does a phenomenal job amplifying calls to action. So if you were engaged in that in any capacity, thank you. LWVUS also submitted written testimony for the Senate hearing in support of the ERA, going on formal record in front of Congress that we support the resolution and we support the publication of the Equal Rights Amendment. Then back in 2023, in anticipation of the Senate vote, we sent a memo urging senators to vote in support of the resolution. And we also sent a memo to the House urging support of their resolution. And we had dozens of meetings with members of Congress in both chambers and on both sides of the aisle to educate on the status and importance of the ERA. And then finally, to demonstrate nationwide support for the ERA, LWVUS, with sign-on from all 51 state leagues, sent a letter to both Congress and the administration, urging them to take respective actions on the ERA. However, by the end of last year, there was not a path through Congress, and again, congressional action is not requisite for ERA publication. So that brings us to the administrative advocacy. Following the outcome of the 2024 election, and this was about a 2.5 month period, so obviously all cylinders fire, LWVUS launched a campaign to directly urge President Biden to instruct the U.S. Archivist to certify and publish the ERA in the Constitution. We put an action alert on our website so people could contact the White House and Vice President's office, urging Biden to ensure ERA publication. And that's garnered more than 48,000 letters to the offices thus far, which is a pretty significant number for a network in such a brief period of time. LWVUS also shared a letter to the editor template with our state and local leagues, many of whom have gotten published on this issue in their respective papers. And we joined the newly formed Biden Published the ERA Alliance, which is made up of other advocacy organizations working really, again, all cylinders fire for ERA publication. This allowed us to cross-promote events, including a virtual town hall with Senator Gillibrand urging the president to act, a virtual film screening on a documentary looking at the history of the ERA, and a DC-based rally. And then an action that I'm particularly proud of, because anybody who's done sign-on letters knows this is a really big lift. LWVUS, in coordination with Shattering Glass, authored a nonprofit advocacy letter to the president, which also went to the vice president's office, and it emphasized the prospective impact of the ERA on reproductive rights. And this is particularly important because historically there has been a little bit of a divide between the ERA and reproductive rights advocacy community for reasons that we are aware of and things that we don't fully understand, but it was a good way to bring diverse nonprofits together. In total, the letter represented 143 nonprofits, including some really major organizations like the National Council of Negro Women, as well as legal associations and medical societies. So just taking a breath here. I know, again, that's an inordinate amount of information, and we can reiterate it and we can go through Q&A. We only have a couple slides left, but I do want to level set so you can have an idea of how much legwork has been done. Let's take a look at the current state of play in advocacy kind of across sectors. So in August 2024, the American Bar Association, representing more than 400,000 legal professionals, adopted a resolution recognizing the Equal Rights Amendment as the 28th Amendment to the Constitution and urging its implementation. That's an enormous statement. And the ABA doesn't typically put out policy statements of that sort. In October, the American College of Obstetricians and Gynecologists, in coordination with 6 medical societies, urged the president to act. And that's also a huge deal to have the medical community, particularly in a post-Roe America, coming out and saying, we absolutely need this policy in order to provide quality health care. And in the past 2.5 months, the president's received letters, all with the same ask of instructing the archivist to certify and publish the ERA from 46 U.S. senators, 122 U.S. representatives, legal associations, labor movement leaders, more than 60 faith organizations, and as I'd mentioned, 143 diverse nonprofits. Those are just screenshots of the first pages of those letters. So they've been hearing from us. So as I said, we've done a lot of legwork, and at this point, the best thing that we can do before the inauguration is to continue to build public awareness and public pressure on the president to take this action as an important part of his legacy. So what can you do? As we know, change is incremental, and that can be really disheartening to not see change right away, or frankly, to not see change for decades. We have, however, seen a huge shift in awareness about this issue, which is why we need to keep showing up. And a lot of change starts with public education, just as you're doing with today's event. In a very similar vein, we can help further the movement by speaking about the ERA accurately and with a unified voice, even when we're just discussing it with friends and family, because honestly, that's where changing minds starts. So I've pulled out some top-line bipartisan talking points, and as you can see on the screen, those include: the ERA will constitutionally protect equality of rights under law regardless of sex. The ERA has met all ratification requirements, but has not been published. Women continue to face discrimination based on sex. That's clear in these numerous ongoing fights. And nearly 80% of Americans favor adding the ERA to the Constitution. That's according to Pew Research. And then looking at resources that LWVUS has to offer you. First, if you haven't already, you can complete our action alert on the ERA to the White House. It truly takes 60 seconds. You'll put in your name and your address. You can add a personalized touch, which we've heard often constituents personalizing and explaining why something would impact their life is really beneficial. And then if you can pass that along to your friends and family, it will really help magnify the impact. If you don't want to spam a bunch of people, I just tell my friends, send it to 3 for equality. That's not a huge lift, and it does allow us to really reach out laterally. If you represent a local or state league, you can use our ERA letter to the editor template to submit a piece to your local paper. And like I said, we've already seen many of those published across the country, which is really helpful in fighting a little bit of a media blackout that we've seen on this issue for about 5 years. And you can also go to the bottom of the homepage on our website and sign up for league emails on urgent issues. Those include regular content and calls to action on the ERA. Please note that this will put you into our email system, and I also presume a lot of folks on the call are already getting those emails. But if you're not, please sign up, and if the content isn't resonating, you can unsubscribe at any time. And I just want to say lastly, at LWVUS, we are continuing to adapt and implement our ERA advocacy strategy. We hope that President Biden will publish before leaving office. If not, we may be looking at a congressional strategy again. We will be definitely continuing to push federal advocacy, public education, and leveraging the power of our grassroots network to support publication once and for all. We need the Equal Rights Amendment. We've seen it, we're living it, and our voices and efforts in this fight really are what will ultimately get it published. So we really look forward to continuing this vital work together, and thank you all for your time. And I will just open up the floor to questions now. And I think I'm going to stop sharing my screen so that we can see as much of one another as possible.
Thank you so much, Rebecca. That was so concise and so clear. You took this really complicated topic that we all know bits and pieces about from hearing and put it together in a way of really understanding what's currently happening. And just thank you for putting that together for us. I can't there is a question in the chat that I'm going to read that can you advise talking points to allay fears that it would undermine existing protections for women, such as exemptions for military service?
Yeah, and Particularly if you're looking to meet with a legislative office like your elected official and you'd like concise talking points and you want to reach out to me, I'll share my email with you, Catherine, so that you can circulate to folks. I'm more than happy to produce those. But this is the nature of judicial scrutiny. If we were to elevate the level of judicial scrutiny that's used to review claims of sex-based discrimination, it doesn't prohibit governments from differentiating on the basis of sex. It would require a more stringent review. The government would have to have a compelling interest to make sex differentiation. So for example, when we hear kind of fear-mongering talking points about the elimination of single-sex spaces like prisons, or oftentimes we hear it in the context of bathrooms, changing rooms, et cetera. The government, on a case-by-case basis going through the courts, would have to have a compelling interest to make that differentiation. With regards to the military service, we don't actively have a draft right now. There have been policy suggestions from the military that if a draft were reinstated, it did not discriminate on the basis of sex, and that would likely go up to the Supreme Court. So at this point, while we don't have an active draft, compulsory military service under existing legal precedent would likely apply to men, women, gender diverse folks alike anyway. So this talking point about military service, about single-sex spaces, the things that really kind of create emotion in people are the same opposition talking points that have been used since the Phyllis Schlafly anti-ERA campaign back in the 80s. But I have yet to talk to an attorney who has a credible concern about losing some kind of protection for women, and military service is definitely not an exception there.
We have Bobby Francis has been raising her hand. Bobby, do you want to ask your question?
I'll ask a question, but I first must say brava, Rebecca. That was the best summary I've ever heard in concise, just everything. That was super. Thank you so much.
And anyone here who knows Bobby knows that's high praise, because Bobby is absolutely an ERA warrior. So thank you. Appreciate that.
Well, thank you. And just 45 seconds, but I cut my teeth on the ERA was my feminist clique in 77 when I was Chatham Borough League of Women Voters president here in New Jersey. And I took off from there. And Rebecca and I have both attended the ERA Coalition Zoom meetings. So we may see each other again tomorrow at 1. But I just wanted to, first of all, say that was the most wonderful summary, done so well. Thank you. And also that if some people would want to follow up a little more on details about some of the points, the Alice Paul Center for Gender Justice in New Jersey also, a lot of folks probably know that, has a www.equalrightsamendment.org website. And the FAQ page there, which, not to pat myself on the head, but I write the FAQ page for that. And that has a lot of more detail that, could amplify some of what Rebecca said so well. But I wanted to say right now, primarily, and Rebecca's heard discussion of this too in the coalition Zooms, there seems to be some reluctance. Rebecca, you may know from experience with contacting the White House or so, but the executive branch has no authorized role in the constitutional amendment process. And my understanding is that some of the reluctance of the White House to have President Biden direct the archivist to publish is because it doesn't feel correct under the way the Constitution gives power to just Congress to pass it out and the states to ratify it. But I keep saying I'm not a lawyer, but I play one on the ERA, and I have been looking at another basis that I think the president has to tell the archivist to do it, and it's the president's constitutional duty under Article 2, Section 3 to, the phrase is, take care that the laws are faithfully executed. And since 2020, the archivist and his successor have been breaking the law around constitutional amendment process by not publishing. And so we are just, this is not to go into great detail, but to say that we've been working on trying to get that message to the White House and saying, if your reluctance is in part because you say the Constitution doesn't have an authorized role for the executive branch, here's your basis for authority. So I don't know, Rebecca, you don't need to go into that in any more detail, but I did want to put that on the table because right now, knock on wood, we are getting that message into White House locations just from my doing it, from my understanding and pipelines I've worked on just in the last few days. So whether we see any change, I don't know. And I don't know if the league would think that one thing it could pick up on right now is to be delivering that message about his authority through the take care charge for him to do that in Constitution's Section 2 or Article 2. Thanks. Didn't mean to go on so long, but we're also committed to this. Thank you.
Yeah, so Bobby, I've heard your legal argument and I have your fact sheet. Admittedly, I haven't run it through LWVUS's litigation team to approve that as a public talking point from a league vantage point, because obviously we've got our respective processes, but more than happy to do so. But reiterating what Bobby said and some of the points that I had made throughout the presentation, we're talking about a fully ratified amendment. The actors who actually have constitutional authority to take action have. However, the National Archivist has a statutory duty to certify and publish, and she's not done so, and she is a presidential nominee.
If I may just add, apologies, but yesterday there was a report that Donald Trump in an interview the evening before had said, when he was asked, shouldn't he get another archivist who would not do things like say he had taken classified documents? He said publicly, yes, I'll fire this archivist. So as far as I know, in the last 48 hours, she's had a shot across the bow that she may not last in that role too long. So all of this is just happening, almost day after day, there's some new development.
We also have thank you both. Sorry, the legalities it's amazing to have both experts here because the legalities of it, I think, is what kind of gets people confused and maybe a little hesitant to approach the topic. But I definitely appreciate that deeper dive. There is a question at the library from Georgianne, I believe. Come closer, Georgianne. Be careful.
Thank you for taking my question. My question really is, what's the problem with Biden? And that has been partly answered by Bobby. I would like to remind everybody that you can only leave a message at the White House phone line from Tuesday to Thursday between, I think it's maybe 9 and 3. So if you're thinking of calling and leaving a message, do it tomorrow. I think that we have some good ammunition here from Bobby. I can't imagine why we're talking about this. So that, while I listened, I thought, what is his problem? And I guess his problem is that he's not mentioned in the Constitution. I mean, I know the guy's really busy, but this is really important. So if anybody has any more information on what the problem is, I'm open-eared, but thank you, Bobby.
Yeah, we can surmise, like Bobby said, there may well be significant discomforts that the president doesn't actually have a constitutional role in the amendment process. Obviously, that's presuming that the amendment process goes according to plan as per the Constitution. It's possible that he has concerns that if Congress doesn't proactively pass a resolution, it will be challenged in a court and he'll be somehow held culpable for that challenge. Some folks have surmised that he may have discomforts related to the prospective impact on reproductive rights as a devout Catholic. There are suppositions about political parties wanting to continue to run on the issue. Your guess is as good as my guess is as good as Bobby's guess, and I'm sure we all have our own opinions informed by this work and our understanding of politics. A point that I do think is worth making there are only 2 U.S. presidents under whom a fully ratified amendment hasn't been put in the Constitution, and that is President Trump and President Biden. Both presidents have sat on the Equal Rights Amendment. So if President Biden doesn't want to share that legacy, he should instruct the archivist to certify and publish.
I like that.
Okay, I see a question in the chat. Is there a risk that such a challenge in the court could be a setback given the state of SCOTUS? Yes, absolutely. Just like we don't know the exact way that the ERA will be used to address claims of sex and gender-based discrimination in any individual court and any individual case, we don't fully know what would happen if its constitutionality was challenged and it made its way up to the Supreme Court. The upside is this: an originalist constitutional interpretation would suggest that the Equal Rights Amendment is duly ratified, is the 28th Amendment, and should stand. The other thing is, as we discussed, Article 5 of the Constitution endows Congress with the power to pass an amendment and then the states with the power to ratify. If we're talking about questions about that time limit for states to ratify, there is no place in the U.S. Constitution that gives Congress the power to impose a ratification time limit, much less to curtail state ratification rights. So again, if we're looking at the word of the Constitution and we're under the presumption that the current Supreme Court interprets the Constitution as it were written, the ERA should be a fully ratified amendment that stands.
I just want to see if there's any other questions. It looks like Georgianne might have another question in the back.
Well,
Remember,
yes,
we have our
if you-
nonpartisan hats on, Georgianne.
If you know the history of the other amendments, was there ever another time limit set for previous amendments? I'm just curious. I don't know the answer to that.
Yes, so there have, and Bobby might know. So let me start with this. The amendment process for every amendment in the Constitution, all 27, has looked a little different because each time it's had slightly unprecedented circumstances around it. The 28th Amendment, the ERA, is no exception. There have been proposed constitutional amendments with time limits in the amendment text, in the amendment language, where the time limits have expired before all states have ratified, and they have been considered deceased. Because when you send a congressionally approved amendment to the states and the states ratify it with a time limit in the language itself, the states have not only ratified the amendment, but they've also ratified the amendment time limit. And I know we're really splitting hairs here, but that is the difference. That is, states who ratified the Equal Rights Amendment did not ratify that 7 or extension 3-year time limit. So we're talking about an entirely unprecedented situation of a fully ratified amendment with an expired time limit that was in the proposing clause of an amendment, not the amendment text itself. I see Catherine like, oh, this is painful. It is painful, but it's an important distinction. We do also have some great precedent when it comes to other amendments, like the 27th Amendment was put into the U.S. Constitution 203 years after introduction. So if someone says, well, this seems like 101 years seems like a long time for the ERA to go into the Constitution. Well, if 203 years isn't too long, 101 years isn't too long. The other thing we hear is some folks have purported to rescind their ratifications. Let's be really, really careful when we talk about this issue. States haven't rescinded their ratifications, they've purported to rescind. And we have precedent for this as well. when the 14th Amendment and 19th Amendments were being ratified, some states also purported to rescind their ratifications. And not only were those rescissions never recognized by the National Archives and Records Administration, but those states that said, we take it back, were actually delineated as final ratifying states. So Article 5 of the Constitution gives states power to ratify. It does not give states power to rescind, and there's no legal precedent for rescissions. So we do have a lot of legal support when it comes to the history of other amendments, even though we're looking at kind of an unprecedented conglomerate of factors here.
And it's painful because it should just be, Rebecca. It should just be like that. We have to split hairs about the legality of the congressional memos that have been extended the time limits, and the political back and forth that has gone on about the issue infuriates me, because when, at the very basis of it, but it has turned into my favorite bipartisan talking point, and where I try to really like just make connections with people. Like, of course we want this. Like, why are we fighting about it? Like, why can't we just have it? Like, if it's not a big deal, can't we all just like agree on this one thing that we like have agreed on for a long time? Like, it feels like it shouldn't be hard. And Bobby, I think, has her hand up again. If you have something, go ahead. Oh, you're still on mute. Sorry, Bobby.
I just wanted to say, if somebody else is wanting to
No,
ask
you're
something,
fine.
I put it up when Rebecca, you're blowing me away, Rebecca. This is fabulous. You're doing such a great job. But when you talked about answering the question about could it be a setback for women and so on, I think that there is some crosstalk within the advocates working together. And some are saying, well, maybe we don't want to get it published because that, my understanding is that sort of sets it up as a sitting duck for a hostile court, especially all the way up to the Supreme Court. But to me, the argument that I was going to say trumps that, but I won't say that. The argument that overrides that is that, and the archivist in 2012, David Ferrier, the former one, wrote to Carolyn Maloney, the New York representative who has been a champion of the ERA, that when it is finally published, he said when the complete execution of 1 U.S.C. 106B, the law governing it, happens, and that means through publication, then the amendment is in the Constitution, and the only thing that could remove it is another constitutional amendment, as we saw with prohibition. It's the only time it's happened before. And my argument is that when it is published, that is very meaningful. It's not necessary to say that publish it to make sure it is ratified. It is ratified now. But the archivist's role of notifying the country that it's ratified is the final step in that law. And when that happens, as the archivist wrote to Carolyn Maloney, then the only thing that could take the ERA out of the Constitution is a subsequent constitutional amendment. To me, that overrides any concerns about what courts would do. These courts, I mean, thank goodness President Biden had, Rebecca, you may know for sure, I think he ended up being able to appoint one more member to the judiciary than Donald Trump did in his first term. But anyway, even though we say, oh my goodness, all those conservative or reactionary lawyers, we do have the same number plus one, I believe, put in by President Biden. And I think that anything the hostile courts would want to do, they're going to try to do whether or not it's published. So I don't think failure to publish is much protection about that. It is protection against a court not being able to say it's not duly ratified, because the only way to get it out would be another constitutional amendment. And talk about, Catherine and Rebecca, talk about all the details. But
it's so hard. One of the other details I want to make sure that we get, because we have another question in the chat, and we'll wrap up for our educational portion, is what is the correct link, Rebecca, for the action alert? I hope that I didn't put the wrong one in the chat earlier, because Valerie, I put one in the chat and that one went to the senators and the US reps and not the White House directly. So there is one that goes right to Biden, right?
Yep. So
I have his like text number now. Does that go anywhere? Is that actually reaching, or is that also turned off as I'm hearing that you can only call the White House at certain times?
my understanding, and someone here can correct me if I'm wrong, is that text is 24/7, not that someone's monitoring it. We do not have the White House number on the website currently, I don't believe. I've just dropped the action alert in the chat to the White House. And Valerie, to answer your question, so the action alert had gone to representatives when we were, to senators and representatives when we were trying to garner support on that bipartisan resolution affirming the validity of the ERA, and then a couple days leading up to the election in anticipation of Congress not taking sufficient action, we prepared the White House action alert.
Ah, perfect. Thank you.
Mhm.
And if there's no other questions, I just again want to thank you, Rebecca. And as others have said, that really was an incredible presentation of getting us to understand where we are and the history of it in a really concise way. I hope everyone who is joining tonight or watching this video will take that action with us and really take away that sentiment that, you know, us understanding these issues and just sharing in a very serious way with our friends and family about the importance of this issue can have a really important impact. And I hope that all of us who are on here will continue to spread that message and join me in thanking Rebecca for attending. But if you are a member, please stay on. But everyone else will say thank you for joining us. It was just incredible. Please stay in touch. You were born in New Jersey or lived in New Jersey?
Yeah, I was born and raised in Princeton.
She's a Jersey girl, so you need to come to one of our meetings. Let us know when you're in town. We have a lot going on in the state. We just are so appreciative to have you in DC working on these issues and helping us stay connected on them. So please stay in touch with us, and I'll follow up with any questions that come from our members or from those that have joined us tonight.
Okay, that sounds great. Yeah, I will send you my contact information, all of the hyperlinks so you can share with membership. More than happy to circle back with any questions. And the one thing I'll say is I've gotten a lot of flack for being born and raised in New Jersey and not knowing how to pump my own gas when I left
Central Jersey too.
Central Jersey, nonetheless. Yeah. But I have seen more and more people talking online about the New Jersey sparkle. And they're like, sometimes you just meet someone and you go, I wonder where they're from. And it's always New Jersey. So
we run the world, I tell you what. So keep it up and let us know how we can help and what we can do to back up the incredible work that you're doing.
sounds great. Thank you all so much.
Thank you, Rebecca. And members, please stay on. We have a very short amount of business to get through. Just catching up. We didn't have our December meeting. It would be great. We'll get the hyperlinks. I'll get the presentation slides. She was great. She really, after our November meeting, I kind of